Before we begin, a quick and important disclaimer. This video and the information contained within it are provided for educational and entertainment purposes only. The content discussed here does not constitute professional legal, financial, or tax advice, and it should not be used as a substitute for consultation with a licensed attorney or a qualified professional in your specific jurisdiction. Law and legal procedures vary significantly by state and change over time. Viewers are strongly encouraged to conduct their own due diligence and seek independent professional counsel before making any decisions related to legal matters or domestic relations. In 1924, if you wanted to end a marriage in the United States, you didn't just need a lawyer. You needed a detective, a witness to a crime, and quite often a staged photograph of a hotel room betrayal. For the better part of the last century, the American divorce lawyer has occupied one of the most controversial, high-stakes, and misunderstood roles in the U.S. legal system. Today, divorce is a $50 billion industry, but 100 years ago, it was a social death sentence handled in the shadows of the courtroom. We are looking at a profession that has shifted from the shyster labeling of the early 20th century to a sophisticated machine involving forensic accountants, psychological evaluators, and elite litigators who manage the dissolution of massive estates. This deep dive masterclass is going to peel back the curtain on how this profession was built, the hidden mechanics of how these cases are actually won and lost, and why the business of breaking up has become a fundamental pillar of the American economy. By the end of this series, you will understand the precise evolution of family law, the tactical maneuvers used in high-net-worth splits, and how historical trends have shaped the potential outcomes for millions of Americans today. We are solving the mystery of the legal battlefield that nearly 50% of the population will eventually step onto. To understand where we are now, we have to go back to an era where the concept of irreconcilable differences didn't exist. In the early 1920s, the divorce lawyer was essentially a specialist in the law of fault. You could not simply decide to leave. You had to prove that your spouse had committed a specific legal transgression. This period created a bizarre legal theater. Lawyers had to prove grounds such as adultery, extreme cruelty, or willful desertion. Because the legal bars were so high, the profession saw the rise of the collusive divorce. This was a period where lawyers on both sides would essentially script a scenario to satisfy the judge. Case studies from the 1930s show a recurring pattern where a husband would hire a woman to be photographed with him in a hotel room, fully clothed, but in a suggestive enough setting to provide evidence for the court. The lawyer's job in this era wasn't just about the law. It was about stage management. If the judge suspected that both parties actually wanted the divorce, he could dismiss the case on the grounds of collusion. It was a paradox. You had to want to leave, but you had to pretend you were being forced to leave by the other person's crimes. This rigid system led to the birth of the divorce colony. For decades, Nevada, and specifically Reno, became the divorce capital of the world. Divorce lawyers in Reno built an entire economy based on the 6-week residency. While other states required years of separation or impossible proof of fault, Nevada lawyers capitalized on lenient state laws. This was the first time in U.S. history that the divorce lawyer became a high-volume business mogul. They weren't just practicing law, they were managing tourism. They would meet clients at the train station, set them up in divorce ranches for their 6-week stay, and then walk them through a 5-minute hearing. Historical trends show that by the late 1930s, Reno was processing over 30,000 divorces a year. This period is crucial because it established the divorce lawyer as an essential economic actor. It proved that where there is a legal barrier to personal freedom, a specialized legal industry will inevitably rise to bypass it. As we move into the post-World War II era, the role of the lawyer shifted again. The 1940s and 50s saw a massive spike in filings as soldiers returned from overseas to marriages that had been strained by years of distance. During this time, the divorce lawyer began to transition from a theatrical coordinator to a financial strategist. As the American middle class grew, so did the complexity of the marital estate. It was no longer just about who got the house. It was about pensions, emerging corporate benefits, and the early iterations of the suburban dream. Lawyers had to become experts in property division during a time when the law was still heavily biased toward the breadwinner, who was almost always the husband. The most radical transformation, however, occurred in 1969 when Governor Ronald Reagan signed the California No-Fault Divorce Act. This was the seismic shift that created the modern divorce lawyer we see today. No-fault divorce removed the requirement to prove a wrong had been committed. It allowed for the dissolution of a marriage based simply on the fact that the relationship had broken down, Critics at the time thought this would put divorce lawyers out of business. They assumed that if there was no fault to argue about, there would be nothing for lawyers to do. The reality was the exact opposite. When the focus shifted away from who did what, it shifted toward who gets what, and where do the children go. The no-fault era birthed the era of the forensic divorce. Because lawyers no longer spent their time hiring private investigators to catch spouses in the act, they redirected that energy into the discovery phase of litigation. This is the part of the process where lawyers dig through every bank statement, tax return, and investment portfolio. In the 1970s and 80s, the divorce lawyer became a hybrid of a litigator and an accountant. This is also when we saw the rise of equitable distribution versus community property states. Understanding these historical trends is vital because it dictates the potential outcomes of every modern case. In a community property state, the lawyer's job is a mathematical one. Split everything 50-50. In an equitable distribution state, the lawyer's job is a persuasive one. Argue why their client deserves a larger share based on their contribution to the marriage, their future earning potential, or the needs of the children. By the 1990s, the profession reached another milestone: the celebrity megadivorce. This period saw the lawyer become a PR strategist. High-stakes cases involving hundreds of millions of dollars meant that a lawyer's work was no longer confined to the courtroom. It was managed in the court of public opinion. Lawyers began using non-disclosure agreements and private mediation to keep the details of wealthy splits out of the tabloids. The modern divorce lawyer is now the architect of the global split. We see cases today where a couple might have property in New York, a business in London, and offshore accounts in the Cayman Islands. The lawyer has to navigate multiple jurisdictions, international treaties, and complex tax codes. When we look at the data today, the divorce industry is remarkably resilient. Even as marriage rates in the U.S. have seen a slight decline over the last decade, the complexity of separations has increased. We are seeing longer marriages end, often called gray divorce, where the legal challenges involve healthcare proxies, social security benefits, and the division of long-term retirement accounts. The divorce lawyer in 2026 is no longer just a hired gun for a fight. They are project managers for the restructuring of a life. They manage a team that includes therapists to handle the emotional volatility, vocational experts to determine a spouse's ability to return to the workforce, and child advocates to ensure the best interests of the minors are met. This masterclass is designed to walk you through every layer of this evolution. We will examine the specific strategies used in the initial filing to gain leverage, the discovery tactics used to find hidden assets, and the negotiation frameworks that prevent cases from going to a full-blown trial. We are not just looking at the law, we are looking at the psychology of negotiation and the economics of the family unit. Historically, those who understand the mechanics of the system have seen more favorable potential outcomes than those who enter the process blindly. This series serves as the definitive guide to understanding the history, the present reality, and the future trajectory of the divorce lawyer in America. We are moving from the staged hotel photos of the 1920s to the algorithmic asset division of the modern era. Step by step, we will break down the most expensive and life-altering legal process in the United States. To understand the true weight of the American divorce lawyer, we have to look at the era of the Great Divorce Migration. Imagine you are a woman named Evelyn living in New York City in 1935. You are in a marriage that is not only emotionally dead but physically unsafe. Under New York law at that time, your only path to legal freedom is to prove adultery. There is no other way. This created a massive problem for the legal profession. How do you provide a service for a client when the law itself is an immovable wall? This birthed the first generation of what we might call the tactical divorce specialist. These lawyers realized that while the law was rigid, the geography of the United States was flexible. The potential outcomes for a client like Evelyn depended entirely on her lawyer's ability to navigate the jurisdictional loopholes of the mid-20th century. This gave rise to the Reno divorce. Lawyers in New York would partner with practitioners in Nevada to facilitate what was essentially a legal pilgrimage. The lawyer's role was to guide the client through a 6-week residency requirement. Imagine the logistical precision required here. The lawyer had to ensure that Evelyn moved her entire life to a Nevada dude ranch for precisely 42 days. If she left for even a weekend to visit family, the residency clock reset, and the legal strategy collapsed. The attorney was no longer just a legal advisor. They were a travel agent, a residency auditor, and a social coordinator. In Reno, the lawyers occupied offices that were strategically placed right across from the courthouse, creating a high-speed assembly line of marital dissolution. Historical trends show that during the height of this era, a single judge could grant dozens of divorces in a single morning. The lawyer's job was to present a very specific, rehearsed set of facts. Because the bar for fault was so high in the home states, lawyers began to master the art of mental cruelty as a secondary legal tool. This was a masterclass in subjective litigation. If a spouse could not be caught in an affair, the lawyer would coach the client to testify that the spouse's behavior, perhaps their silence at dinner, their refusal to socialize, or their criticism of the client's housekeeping, caused extreme nervous tension and physical illness. This was the first time we saw medical testimony integrated into the divorce process, as lawyers brought in sympathetic doctors to testify that the marriage was literally making the client sick. As we moved into 1946, the end of World War II created the single largest spike in divorce filings the U.S. had ever seen. The return of millions of soldiers led to a breakdown of wartime marriages that had been built on haste and distance. The legal system was completely overwhelmed. Lawyers who had previously handled a few cases a month were now seeing hundreds. This period transformed the divorce lawyer from a niche practitioner into a fundamental part of the American legal infrastructure. Case studies from 1946 show that lawyers began to use the interlocutory decree as a strategic weapon. In many states, once a judge granted a divorce, it wasn't actually final for 6 months to a year. This was called the cooling-off period. Lawyers in the late 1940s used this time to monitor their clients' behavior, warning them that if they were seen in public with a new partner before the final decree was signed, the entire case could be reopened on the grounds of misconduct, potentially stripping them of their alimony. Alimony during this century was the primary battlefield. Before the rise of the two-income household, the lawyer's primary objective was to secure a life pension for the wife. Because a divorced woman in the 1950s faced significant social stigma and limited employment opportunities, the legal fight was a fight for survival. Lawyers would conduct deep-dive audits of the husband's salary, his corporate perks, and even his future inheritance prospects. They weren't just looking at what he earned, they were looking at what he would earn over the next 30 years. This is where the divorce lawyer began to function as a forensic financial analyst. They had to account for the inflation of the post-war economy and ensure that the support payments would sustain a middle-class lifestyle indefinitely. By the early 1960s, the role of the private investigator became inseparable from the role of the divorce lawyer. Imagine a lawyer's office in 1962. It wasn't just filled with law books, it was filled with surveillance reports. Because fault was still the primary driver of settlements, the lawyer's most powerful tool was the keyhole photo. This era is often called the keyhole era of family law. Lawyers would spend thousands of dollars of the client's money on teams of investigators to follow the opposing spouse. The step-by-step process was grueling. Identify the routine, find the location of the infidelity, and then execute what was known as the raid. The lawyer would often be the one to review the grainy, black and white photos to determine if they were legally sufficient to force a settlement. This was a high-stakes game of leverage. If the lawyer had the photos, they could often bypass a trial and force the other side to sign over the house and the savings account just to avoid public scandal. The business of the divorce lawyer also had to contend with the rise of the migratory divorce outside of U.S. borders. For those who couldn't wait 6 weeks in Nevada, lawyers began facilitating the Mexican quickie divorce in places like Ciudad Juarez. This was a legal gray area that required the U.S. lawyer to be an expert in international recognition of foreign decrees. Case studies from the 1960s show that many of these divorces were later challenged in U.S. courts, leading to decades of litigation over whether a person was actually married or not. The lawyer had to be a master of the full faith and credit clause of the Constitution, arguing that one state must recognize the legal actions of another, even if those actions were facilitated in a foreign country. In today's context of 2026, we see the echoes of these historical maneuvers in the way high-net-worth individuals handle jurisdictional shopping. Just as a 1930s socialite might flee to Reno, a modern tech mogul might try to establish residency in a state with more favorable asset protection laws before filing. The tactics have evolved from physical presence to digital footprints. In 2026, a lawyer is looking at a client's GPS data, their Amazon delivery history, and their social media check-ins to prove that they actually live in the state where the filing occurred. The lawyer's role in auditing residency has moved from checking ranch registers to analyzing cloud-based metadata. The evolution of the divorce lawyer in the mid-century also saw the birth of child custody as a distinct legal specialty. Before this, children were often treated as secondary to the property division, frequently defaulting to the mother under the tender years doctrine. However, as the 1960s progressed, lawyers began to use custody as a bargaining chip in financial negotiations. This forced the legal profession to adopt a new set of skills. Lawyers had to become familiar with early child psychology and the emerging social work standards of the time. They began hiring the first generation of guardian ad litem practitioners, lawyers specifically appointed to represent the children's interests, marking the first time the legal triangle of mother, father, and state was fully formed. But as the 1960s drew to a close, the entire foundation of this fault and surveillance industry was about to be obliterated. The lawyers who had built their careers on hotel room photos and mental cruelty coaching were suddenly faced with a legal revolution that would change the business of breaking up forever. A single signature on a piece of paper in California was about to turn the 50-year-old business model of the American divorce lawyer completely upside down. If fault didn't matter anymore, what would the lawyers actually fight about? Next, we are diving into the era of the no-fault explosion and the rise of the billion-dollar split, where the battlefield moved from the bedroom to the boardroom, and the secret tactics lawyers used to find money that didn't technically exist on paper. The signing of the California No-Fault Divorce Act by Ronald Reagan in 1969 was the spark that ignited a total restructuring of the American legal profession. Before this moment, the lawyer was a storyteller who had to find a villain. After this moment, the lawyer became a forensic architect. The focus shifted from the why of the breakup to the what of the estate. This era, spanning from the 1970s through the high-flying 1980s, transformed the divorce lawyer into a specialist who could navigate the labyrinth of corporate structures and hidden wealth. When the law stopped asking who was at fault, it started asking where the money was hidden, and the answers were often buried under layers of complex financial engineering. Imagine a scenario in 1982. We will call our couple Robert and Sarah. Robert is a senior executive at a growing telecommunications firm. He has a base salary. His true wealth is tied up in stock options that have not yet vested, a deferred compensation plan that pays out in 10 years, and a company car and club membership that do not appear on a standard W-2. In the pre-no-fault era, Sarah's lawyer would have focused on Robert's late nights at the office to prove abandonment. In the new era, Sarah's lawyer is hiring a forensic accountant to value a future that has not yet happened. This is the birth of the valuation war. The potential outcomes for Sarah changed from a small alimony check to a significant percentage of a corporate empire that Robert had not even fully realized yet. The lawyer's primary tool in this decade became the discovery process. This is a step-by-step legal extraction of information that can last for months or even years. It begins with the interrogatories, a series of written questions that the opposing spouse must answer under penalty of perjury. A modern lawyer in 2026 still uses this foundational 1970s tactic, asking questions like, list every bank account you have held an interest in, anywhere in the world, over the last 5 years. But the real meat is in the request for production of documents. In the 1980s, this meant boxes of paper. Today in 2026, it means terabytes of data, including Venmo histories, crypto wallet addresses, and metadata from scanned receipts. One of the most famous case studies that defined this era was O'Brien v. O'Brien in New York, 1985. This case sent shockwaves through the legal community and redefined what a divorce lawyer could actually claim as property. Michael O'Brien was a surgical resident. His wife, Loretta, had worked as a teacher to support the couple while Michael went through medical school. Just as Michael finished his residency and was about to embark on a high-paying career as a surgeon, he filed for divorce. Under the old rules, Loretta might have received some basic support, but the medical degree belonged to Michael. However, Loretta's lawyers argued a revolutionary concept. The medical license itself was marital property because it was acquired during the marriage and represented enhanced earning capacity. The court agreed. This created a new specialty for divorce lawyers, the valuation of professional degrees. Suddenly, a lawyer had to be able to calculate the present value of a 30-year surgical career that hadn't even started yet. This led to the rise of the lifestyle analysis. If a husband like Robert claimed he only earned $200,000 a year, but the couple lived in a $5 million home, traveled by private jet, and spent $50,000 a month on credit cards, the lawyer used lifestyle analysis to prove imputed income. This is a step-by-step process where the lawyer works backward from the expenses to prove that the spouse must be hiding income from a side business or offshore entity. Historically, this tactic has been the undoing of many high-net-worth individuals who thought they could outsmart the system by keeping their official salary low. As the 1980s corporate boom took hold, lawyers also had to deal with the emergence of the double-dipping problem. This occurs when a lawyer tries to count a business's value as an asset to be divided, and then also counts the income from that same business to determine alimony. The legal debates over this became incredibly granular, requiring lawyers to understand the difference between book value, market value, and liquidation value. This is where the elite divorce lawyer separated themselves from the general practitioner. An elite lawyer in 1988 was someone who could sit across from a Wall Street banker and argue the nuances of the Black-Scholes model for valuing stock options. The transition into the 1990s added another layer of complexity: the wasteful dissipation of assets. As the no-fault system became the standard, lawyers found that while they couldn't use a spouse's affair to get a divorce, they could use the money spent on that affair to get a bigger settlement. If a spouse spent marital funds on expensive jewelry or hotel stays for a third party, the lawyer would file a claim for dissipation. This required a forensic deep dive into every credit card statement. The lawyer's goal was to claw back every dollar spent outside the marriage and credit it back to their client's side of the ledger. In our current year of 2026, we see the digital evolution of these 1980s tactics. Let's look at a modern character, Marcus, a software engineer in San Francisco. Marcus has been secretly moving portions of his salary into decentralized finance protocols and non-fungible tokens over the last 3 years. His spouse's lawyer in 2026 isn't just looking at bank statements. They are using blockchain analysis tools to track the flow of marital digital assets. The principle remains the same as it was in the O'Brien case. If the value was created during the marriage, it belongs to the marital estate. The lawyer's job has moved from the filing cabinet to the digital ledger, but the objective of total asset transparency has never changed. The 1980s and 90s also saw the legal industry grapple with the prenuptial agreement. Once a rare tool of the ultra-wealthy, it became a standard defensive maneuver. Lawyers had to learn not just how to litigate a divorce, but how to divorce-proof a client before they even said, "I do." This created a fascinating conflict within the profession. One lawyer would draft a prenup to be as airtight as a vacuum, while years later, another lawyer would spend their entire career looking for a single crack, a missing disclosure, a hint of duress, or an unconscionable clause, to blow the whole agreement apart. By the end of the 20th century, the American divorce lawyer had become a master of the paper divorce. This was the art of making a wealthy individual look poor on paper just long enough to settle a case. Lawyers fought against these strategic bankruptcies by filing motions for pendant light support, temporary orders that forced the high earner to maintain the status quo of the household during the litigation. This ensured that a spouse couldn't simply cut off the credit cards and starve the other side into a quick, unfavorable settlement. But as the financial wars reached a fever pitch, a new and much more emotional front was opening up. The focus on money was about to be eclipsed by a much darker and more complex battle: the fight for the children. The 1990s saw the rise of the custody industrial complex, where the lawyer's role shifted from financial analyst to psychological strategist. The tactics were about to get much more personal, and the stakes would move from bank accounts to the very fabric of the American family. Next, we are exploring the rise of the custody wars, where lawyers began using psychological evaluations as weapons, and the emergence of the best interests of the child standard, which turned the courtroom into a psychological laboratory where every parenting choice was put under a microscope. The shift from the financial battlefield to the psychological one was not just a change in strategy. It was a fundamental reconfiguration of how a divorce lawyer spends their day. By the mid-1990s, the tender years doctrine, the historical legal presumption that mothers were naturally better suited to care for young children, had been largely dismantled across the United States. It was replaced by the best interests of the child standard. On paper, this sounds like a more equitable and humane way to handle the dissolution of a family. In practice, it turned the divorce lawyer into a director of human behavior and a curator of parenting reputations. Imagine a scenario in 2026 involving a character named David. David is a senior software architect who has worked 60-hour weeks for a decade to provide a high-end lifestyle for his 2 children. His spouse, Elena, has been the primary caregiver. In 1950, Elena would have been granted custody almost automatically, provided she wasn't proven to be a person of ill repute. In 2026, David's lawyer sees a path to 50-50 custody, or even primary custody, if they can prove that David's involvement is more conducive to the children's long-term stability. This is where the masterclass in custody litigation begins. The divorce lawyer's first move in this modern era is the request for a child custody evaluation. This is a step-by-step forensic deep dive conducted by a court-appointed psychologist or a social worker. The lawyer's role here is highly tactical. They don't just wait for the report, they influence the inputs. Step 1 is the drafting of the order of appointment. A skilled lawyer ensures that the evaluator is tasked with looking at specific issues, such as the other parent's alleged substance use, emotional volatility, or what is legally termed parental alienation. Historical trends show that the 1990s and 2000s saw the rise of the 730 evaluation, named after the California Evidence Code, which became the gold standard for high-conflict cases. The lawyer's job is to prepare David for the clinical interview. This isn't about telling David what to say, but rather teaching him how to frame his history. Instead of saying, "Elena is a bad mother," the lawyer coaches David to say, "I am concerned that the children's academic needs are not being met during Elena's parenting time." The focus shifts from character assassination to a data-driven analysis of the children's well-being. During this evaluation, the lawyer also manages the collateral contacts. These are the teachers, pediatricians, and neighbors the evaluator will call to verify the parent's claims. A divorce lawyer in 2026 will have already reviewed David's text message history and social media footprints. If David has been sending angry texts at 2 a.m., the lawyer knows the case for primary custody is in jeopardy. This has created a new era of legal counseling where the lawyer acts as a behavioral monitor, often telling their client, "Do not send a single text message that you wouldn't want a judge to read out loud in court 6 months from now." The complexity increases when we look at the rise of parental alienation as a legal concept. While controversial in the psychological community, it has become a powerful tool in the divorce lawyer's arsenal. Case studies from the early 2000s highlight how lawyers began to argue that one parent was systematically brainwashing the child against the other. To fight this, lawyers started hiring their own private experts, rebuttal witnesses, to challenge the court-appointed evaluator's findings. This turned custody hearings into a battle of the experts, where the potential outcomes were often decided by which side had the more prestigious psychologist on their payroll. In the year 2026, we also see the massive impact of the digital parent. Lawyers now use apps like Our Family Wizard or Talking Parents as primary evidence. These apps are designed to facilitate communication between divorced parents, but they also serve as a permanent, uneditable record for the court. A lawyer in a 2026 custody case will spend hours analyzing the response times of a client. If David takes 3 days to respond to a question about a doctor's appointment, the opposing lawyer will use that data to argue that he is not an engaged or supportive co-parent. The lawyer has to be a data scientist, looking for patterns in communication that suggest a lack of cooperation. Another major shift in this century of practice is the introduction of the guardian ad litem. This is a third lawyer in the room, appointed specifically to represent the child. This changed the dynamic of the divorce lawyer's job significantly. Now, the lawyer for the mother and the lawyer for the father have to lobby a third party who has the ear of the judge. The strategy involves building a rapport with the guardian ad litem, providing them with organized evidence that makes their job easier, and ensuring that your client appears as the more reasonable, cooperative party. Imagine if David's case involves a move-away request. Elena wants to move from New York to Austin for a new job. In the 1980s, courts often allowed the primary caregiver to move without much resistance. By 2026, move-away cases are some of the most litigated and expensive battles in family law. The lawyer must present a multi-factor analysis: the distance of the move, the reason for the move, the impact on the relationship with the non-moving parent, and the comparative quality of the school districts. The lawyer becomes a geographic and economic analyst, arguing that the move is or is not in the best interests of the child, based on everything from tax rates to extracurricular availability. We must also look at the rise of the parental coordinator. As courts became overwhelmed with small disputes, such as which parent gets the child for a specific 3-hour window on a holiday, the legal system began to offload these decisions to coordinators. Lawyers now negotiate the scope of the coordinator's power in the final settlement. Does the coordinator have the power to change the schedule? Can they make decisions about therapy or religious upbringing? The divorce lawyer in 2026 is an architect of these long-term governance structures for broken families. The cost of these custody wars has skyrocketed. While a standard divorce in the 1920s might have cost a few weeks' wages, a high-conflict custody case in 2026 can easily reach 6 figures. This is due to the involvement of multiple experts, the length of the trials, and the sheer volume of digital evidence that must be processed. Lawyers have had to adapt their business models, often requiring massive retainers up front to cover the costs of the psychological and digital forensic teams they must employ. But even as the fight for the children reaches peak intensity, a new frontier of the divorce lawyer's practice is emerging. It's a frontier that combines the extreme financial complexity of the boardroom with the intense secrecy of the private life. We are entering the world of the hidden billionaire and the shadow assets. As we move into the next part of this masterclass, we will see how lawyers in 2026 are using artificial intelligence and global tracing networks to find wealth that has been moved into the shadows of the internet, wealth that was never supposed to be found. Next, we are diving into the world of forensic asset tracing, where the battlefield moves from the family home to the dark web, offshore tax havens, and the complex world of corporate shells, as we uncover how lawyers track down the money when a spouse decides to go off the grid. The forensic hunt for assets has evolved from looking for a hidden passbook under a floorboard to a global digital dragnet that requires the skills of a data scientist and the intuition of an intelligence officer. In the year 2026, the American divorce lawyer has largely become a manager of information flow. When a spouse decides to go off the grid or move money into the shadows, they are often relying on the belief that the legal system is too slow or too technologically illiterate to keep up. This is a massive miscalculation. Modern forensic asset tracing is a systematic, step-by-step process of closing the exits until the hiding spouse is forced to choose between total transparency or severe legal sanctions. Imagine a scenario in 2026 involving a high-earning executive named Julian and his spouse, Chloe. Julian has spent the last 3 years preparing for this split. He hasn't just been moving money, he has been camouflaging it. He uses what lawyers call the stacked LLC strategy. Julian creates a primary consulting firm, which pays a secondary marketing firm in a different state, which then pays a third entity in a foreign jurisdiction like Nevis or the Cook Islands. To a standard auditor, it looks like Julian's business is simply struggling with high overhead costs. But Chloe's lawyer in 2026 doesn't look at the tax returns alone. They look at the entity map. The first step for the divorce lawyer in this deep dive is the issuance of a wide net subpoena to third-party providers. In 2026, this isn't just about banks. Lawyers now target the digital footprints that financial transactions leave behind. They subpoena data from ride-sharing apps, food delivery services, and high-end travel aggregators. Why? Because while Julian might claim he is living a modest life on a $50,000 salary, his Uber history shows daily trips to a luxury high-rise where he doesn't own a unit, and his DoorDash history shows expensive dinners for two delivered to that same address. This is the beginning of the lifestyle discrepancy analysis. Historical trends show that the most effective way to find hidden money is to find the hidden life it supports. Once the lawyer establishes that the reported income doesn't match the lifestyle, they move to the forensic audit of the business ledger. In 2026, lawyers use AI-driven transaction matching software. This technology can ingest 5 years of corporate and personal bank statements and instantly flag every transaction that doesn't fit a standard business profile. It looks for round number transfers, payments to vendors that aren't registered in the state's business database, and what are known as phantom employees. Julian might be paying a salary to a consultant who doesn't actually exist, with the funds being redirected into a private account. The lawyer's job is to prove that these expenses are not legitimate business costs, but are instead a wasteful dissipation of marital assets. The complexity reaches a peak when we enter the world of decentralized finance or DeFi. If Julian has been moving marital funds into cryptocurrency, he may believe he is untouchable because there is no central bank to subpoena. However, the 2026 divorce lawyer works with blockchain analysts who specialize in chain hopping. They don't just look for a wallet, they look for the on-ramps and off-ramps. Every time Julian used his linked bank account to buy Ethereum, he left a breadcrumb. Even if he then swapped that Ethereum for a privacy coin like Monero to hide the trail, the lawyer can still ask the court for a negative inference. In the legal world, if you can prove Julian had $100,000 in January, and he cannot or will not account for where it went by December, the court can assume he still has it and credit that full amount to Chloe's side of the ledger. Historical trends in the US have shown that the law is slowly catching up to these obfuscation tactics. For instance, the Corporate Transparency Act and the FinCEN beneficial ownership information rules have made it significantly harder to hide behind anonymous shell companies. A lawyer in 2026 uses these federal databases to pull the names of the actual humans who benefit from an LLC, bypassing the layers of nominee managers that Julian used to hide his involvement. If Julian's name pops up as a beneficial owner of a holding company in Delaware that owns a vineyard in Napa, the game of hide-and-seek is effectively over. But what happens when the money is truly offshore? This is where the divorce lawyer's role becomes international. Through a process known as a letter rogatory, the U.S. lawyer can request the assistance of a foreign court to compel evidence or freeze assets. While some jurisdictions are notoriously difficult, many have entered into mutual legal assistance treaties that make the world much smaller for someone trying to hide money. Case studies from the last decade show that even in traditional tax havens, the pressure of international transparency standards has made it easier for forensic teams to get a glimpse behind the curtain. The lawyer's strategy here is often to make the cost of hiding the money higher than the cost of sharing it. By filing motions that require Julian to pay Chloe's massive forensic accounting fees as the case drags on, the lawyer creates a financial drain that eventually forces a settlement. Another critical tactic is the search for shadow assets. These are items of value that don't look like money. In 2026, this includes things like high-value digital collectibles, prepaid luxury memberships, and even unused travel points or corporate perks that have a cash-equivalent value. Lawyers now routinely include these in their discovery requests. If Julian has 1 million airline miles or a lifetime membership to an exclusive club paid for with marital funds, those are considered assets to be valued and divided. The lawyer's deep dive involves looking for anything that represents a future benefit acquired during the marriage. Imagine if Julian tries to use the tactical bankruptcy maneuver. This is a historical favorite where a spouse intentionally crashes their business or files for personal bankruptcy to avoid a divorce settlement. The 2026 divorce lawyer fights this with a motion for the appointment of a receiver. A receiver is a neutral third party who takes over the management of the business to ensure assets aren't being bled dry. This move effectively strips Julian of his control, often leading to a rapid change in his willingness to negotiate fairly. The data suggests that while the methods of hiding wealth have become more sophisticated, the success rate of forensic tracing has also increased. The digital age has made it almost impossible to live a high-status life without leaving a trail. The lawyer's mastery lies in knowing which digital rock to flip over. They are no longer just arguing about the law, they are arguing about the reality of the data. Every swipe of a card, every login to a portal, and every transfer of a token is a potential exhibit in a courtroom. But finding the money is only half the battle. Once the assets are laid bare on the table, the real high-stakes theater begins. We are moving from the forensic lab to the negotiation suite. This is where the divorce lawyer uses the discovered data to construct a settlement that isn't just about the numbers, but about the leverage. The transition from discovery to the settlement table is where cases are truly won, often without a single word being spoken in front of a judge. Next, we are exploring the art of the high-stakes settlement, where we look at the psychological framing used by elite lawyers to force a deal, the secret use of private mediators to keep scandals out of the public record, and how a lawyer turns a mountain of forensic data into a crushing ultimatum. The negotiation table is where the true power of the American divorce lawyer is either realized or squandered. While the public often imagines the courtroom as the primary stage for legal drama, historical trends show that approximately 95% of divorce cases in the United States are settled before they ever reach a final trial. This is not by accident. The transition from the forensic hunt for assets to the settlement suite is a calculated shift from the science of data to the art of psychological leverage. In 2026, the elite divorce lawyer uses a mountain of digital evidence not just to prove a point, but to create a reality so daunting that the opposing side sees a settlement as their only viable escape. Imagine a high-stakes scenario in 2026 involving a character named Samantha, a venture capitalist whose marital estate is valued at $80 million. Her spouse's lawyer has just concluded the discovery phase. They haven't just found the money. They have mapped out the potential outcomes of a trial using predictive AI modeling. This is the new standard in 2026. Lawyers now use software that ingests decades of local judicial rulings, the specific tendencies of the assigned judge, and the current volatility of the assets involved to generate a probability matrix. When Samantha sits down for a four-way meeting, a session involving both spouses and both sets of attorneys, she isn't just looking at bank statements. She is looking at a report that suggests a 72% chance that a judge will award her spouse a larger share of her carry interest in her latest fund. This is the power of anchoring. The initial demand in a high-net-worth settlement is rarely about what the lawyer actually expects to get. It is an anchoring maneuver designed to reset the other side's expectations. If the law suggests a 50-50 split, a sophisticated lawyer might start by demanding 70%, backed by a complex argument regarding the wasteful dissipation of assets or the special needs of the children. By setting the bar at an extreme, they make a 60-40 split look like a win for the other side. This psychological framing is a cornerstone of the American legal tradition. It turns the negotiation into a game of concessions where the lawyer who can hold their ground the longest often secures the most favorable terms for their client. In 2026, we are also seeing the rise of the shadow mediator. Historically, mediation was a voluntary process where a neutral third party helped the couple reach an agreement. Today, it has become a highly specialized industry. Elite lawyers often prefer private mediation because it offers total confidentiality. In the U.S., court records are generally public. For someone in Samantha's position, a public trial would mean her business strategies, her internal emails, and her private financial failures would be accessible to her competitors and the press. The divorce lawyer uses the threat of a public trial as a crushing ultimatum. They effectively tell the other side, "We can settle this in a private office today, or we can air every single one of your digital secrets in an open courtroom on Monday." The step-by-step process of a modern high-stakes settlement often involves the use of the private judge. This is a trend that began in California, but has spread to wealthy enclaves across the country. A private judge is typically a retired superior court jurist hired by both parties to adjudicate the case in a private law firm instead of a public courthouse. The divorce lawyer's role here is to curate the environment. By hiring a private judge, they ensure that the person making the decisions has the time and expertise to understand complex financial instruments like pre-IPO stock or digital asset hedges. In a public court, a judge might have 30 cases on their docket and only 20 minutes to look at a file. In a private setting, the lawyer has the judge's undivided attention for 3 days. Let's look at a case study involving a character named Brandon, a real estate developer in 2026. Brandon has been aggressive in his business dealings, often skirting the edges of tax compliance. During the discovery phase, the opposing lawyer found evidence of these maneuvers. In the settlement suite, that lawyer doesn't lead with a threat to call the authorities. That would be an ethical violation known as extortion. Instead, they lead with a forensic report that details the tax liabilities associated with the marital properties. They frame it as a shared risk. They suggest that if the case goes to trial, the detailed testimony required to value the properties will inevitably bring these issues into the public record. This is the art of the veiled threat. The lawyer creates a scenario where the high earner realizes that the cost of a trial isn't just the legal fees, but the potential destruction of their professional reputation. This era has also perfected the use of the day in the life video as a settlement tool. While originally used in personal injury cases, divorce lawyers in 2026 use these professionally produced mini-documentaries to influence custody and support negotiations. If a lawyer is representing a stay-at-home parent, they might produce a video showing the grueling 24-hour nature of the client's caregiving role. They show this video to the opposing side during mediation. It's a move designed to trigger an emotional response and to demonstrate how the client will appear to a judge or a jury. It moves the conversation from cold numbers on a spreadsheet to a human story of sacrifice and contribution. The legal burn rate is another tactical consideration the lawyer manages. High-conflict litigation is an exercise in financial attrition. A lawyer in 2026 knows exactly how much the other side is spending on their legal team. If they know the opposing spouse has a limited liquid budget, they might use stalling tactics to burn through the other side's retainer. They file motions for clarification, request additional depositions, and challenge minor procedural points. The goal is to bring the other side to a point of financial exhaustion where they are more likely to accept a less-than-ideal settlement just to make the bleeding stop. This is a brutal but common historical trend in U.S. family law. As the settlement reached its final stages in the mid-20th century, it was mostly about the present. In 2026, the settlement is about the future. Lawyers are now drafting clauses that account for the appreciation of assets that don't yet exist. They are negotiating the rights to future name, image, and likeness revenue, especially for clients with significant social media presence or professional brands. The divorce lawyer has to be a futurist, predicting how a settlement signed today will function in a world where the economy might look radically different in 5 years. The ultimate goal of this phase is the Marital Settlement Agreement, or MSA. This document is a masterpiece of legal drafting. A single word, such as shall versus may, can represent $1 million difference over the course of a decade. The lawyer ensures that every possible contingency is covered, What happens if the business is sold? What happens if a child goes to an out-of-state university? What happens if the tax code changes? Once the MSA is signed, the case is effectively over, and the lawyer has succeeded in bypassing the unpredictability of a trial. But what happens when the ego is too big for a settlement? What happens when one side decides that they don't want a deal, they want a total victory? When the negotiations fail and the ultimatums are ignored, the velvet gloves come off. We move from the quiet, carpeted rooms of the mediation suite to the cold, hard benches of the state Supreme Court. Next, we are entering the courtroom masterclass, where we look at the high-stakes theater of the trial itself, the cross-examination techniques used to break a witness on the stand, and the secret ways lawyers use jury-style consultants to win over a single judge who holds the power to redistribute a lifetime of wealth. When the heavy mahogany doors of the courtroom swing shut, the atmospheric pressure of a divorce case changes instantly. In the United States, the trial is the ultimate stress test of the legal work performed over the preceding months or years. While the general public often expects a jury of 12 peers, the reality of the American family law system is the bench trial. This means a single individual, the judge, holds the absolute power to redistribute wealth, dissolve legal bonds, and dictate the future of a family. The divorce lawyer's role transitions from a negotiator to a high-stakes performer where every word, every objection, and every pause is a calculated move designed to influence an audience of one. Imagine a scenario in 2026 involving a character named Jackson, a tech entrepreneur who has built a specialized logistics empire over a 15-year marriage. His spouse, Sophia, has filed for divorce, and the settlement talks have collapsed over the valuation of Jackson's company. We are now in a downtown courtroom. The pacing is deliberate. The lawyer's objective is no longer to find a middle ground. It is to establish a dominant narrative. The first step in this masterclass of trial practice is the opening statement. Unlike in a criminal trial, the opening in a divorce bench trial is a roadmap of equity. The lawyer isn't just reciting facts. They are framing the moral and economic history of the marriage. They are telling the judge, this is the story of a partnership where one party's sacrifice fueled the other's success, and today the bill is due. Historical trends show that the most effective courtroom lawyers are masters of the evidence code. In the hands of a novice, the rules of evidence are a shield. In the hands of an elite practitioner, they are a sword. Step by step, the lawyer builds the case through direct examination. This is where they call their own client, like Jackson, to the stand. The goal of direct examination is to make the witness the star. The lawyer asks open-ended questions: who, what, where, when, and how, to allow Jackson to tell his story in a way that feels authentic and prepared. However, the true theater begins with cross-examination. Cross-examination is the most lethal tool in the divorce lawyer's arsenal. Its primary purpose is not to gather information, but to destroy credibility. In 2026, this is often called impeachment by digital footprint. Let's look at how Sophia's lawyer handles Jackson on the stand. They don't ask him if he's hiding money. Instead, they lead him down a path of short, closed-ended questions where the only possible answer is yes or no. You testified earlier that the company had no liquid reserves in December 2025, correct? And you signed a sworn financial affidavit stating your personal accounts held less than $50,000 at that time? I'm showing you what has been marked as Petitioner's Exhibit 42. This is a metadata-verified screenshot of a digital wallet associated with your hardware device. That wallet held $400,000 in stablecoins on December 15th, didn't it? This is the moment where cases are won. The lawyer isn't just proving the existence of the money. They are proving that Jackson is a liar. In the eyes of a judge, once a witness is caught in a material lie, the legal principle of falsus in uno, falsus in omnibus applies. If they are false in one thing, they are presumed false in everything. A master lawyer knows that the actual dollar amount of the hidden crypto is less important than the total destruction of Jackson's reputation for honesty. If the judge doesn't trust his testimony on the money, they won't trust his testimony on his parenting time or his business valuations. The 2026 trial also features the battle of the experts. This is a sophisticated clash between forensic accountants and valuation specialists. The lawyer's job is to act as a translator. They must take the dense, 300-page report of a forensic accountant and distill it into a 3-minute explanation that a judge can easily digest. Case studies from recent years show that judges are increasingly fatigued by overly complex financial jargon. The lawyer who wins is the one who uses high-quality data visualization. In 2026, This means using dynamic timelines and flowcharts on large courtroom screens to show exactly how money moved from a joint account, through a series of shell companies, and into a private investment. This visual evidence makes the complex theft of marital assets feel like a simple, undeniable story of greed. Another hidden layer of the modern trial is the use of litigation analytics. Elite law firms in 2026 use AI-powered databases to profile the presiding judge. They analyze every ruling that judge has made in the last decade. They know, for example, that this specific judge has a historical trend of being skeptical of stay-at-home spouses who haven't attempted to re-enter the workforce. Armed with this data, the lawyer tailors their cross-examination of Sophia to emphasize her lack of effort in seeking employment, directly tapping into the judge's known biases. This isn't about the law in the abstract. It's about the law as practiced by a specific human being in a black robe. We must also consider the in-camera interview. When children are involved, a judge may choose to speak with them privately in their chambers, away from the parents and their lawyers. A skilled divorce lawyer prepares for this by working with a child specialist to ensure the child's voice is heard without the child feeling the pressure of the conflict. This is a delicate balance. If a lawyer is perceived as coaching the child, it can result in severe sanctions. The lawyer's role here is to advocate for the process itself, ensuring that the judge asks the right questions to uncover the reality of the home life. The final act of the trial is the closing argument. This is where the lawyer stitches together the testimony, the exhibits, and the expert opinions into a final plea for justice. In a 2026 courtroom, this isn't just a speech, it's a digital presentation. The lawyer might play back key moments of a witness's stumbling testimony or highlight a specific line from a bank statement that proves their point. They are reminding the judge that while the law provides the framework, equity provides the soul. They are asking the judge to use their broad discretionary power to correct the imbalances created during the marriage. But the conclusion of a trial doesn't always mean the end of the war. Even after the judge issues a final judgment and decree, the legal machinery doesn't stop. In many ways, the issuance of the court order is just the beginning of a new, even more aggressive phase of the process. Winning on paper is one thing. Actually getting the money, the house, and the custody schedule to work in the real world is another challenge entirely. The battlefield is about to shift from the courtroom to the world of enforcement, where the lawyer must become a collection agent, a private enforcer, and a master of the appellate courts. Many people think that when the judge bangs the gavel, they are finally free. The reality is often much more complicated. Next, we are exploring the world of post-decree warfare in the appellate trap, where we look at how losing parties use the legal system to freeze assets for years after the divorce is supposedly over, and the secret tactics lawyers use to ensure that a win in court actually turns into a win in the bank account. The final bang of the gavel often feels like the finish line. But for a seasoned divorce lawyer in 2026, it is frequently just the end of the first act. Winning on paper is one thing, but converting a judicial order into tangible assets, transferred titles, and consistent support payments is a separate legal discipline, known as post-judgment enforcement. This phase of the process is where many litigants fall into the appellate trap. This is a strategic maneuver where the losing party filed a notice of appeal not necessarily to win a reversal, but to freeze the execution of the judgment for 18 to 24 months. In the United States, historical trends suggest that while only a small percentage of family law appeals result in a full reversal, the mere act of filing can create a massive delay in the distribution of property. Imagine a scenario in 2026 involving a character named Ethan and his former spouse, Isabella. Isabella has just been awarded a $4 million equalization payment to be paid out of Ethan's commercial real estate holdings. To the average observer, Isabella is now a millionaire. However, Ethan's lawyer immediately files a notice of appeal, claiming the trial judge abused their discretion in the valuation of the properties. In many jurisdictions, this filing, combined with the posting of a supersedeas bond, stays the judgment. This means Ethan does not have to pay Isabella a single dollar, while the appellate court reviews the thousands of pages of trial transcripts. The divorce lawyer's role here is to manage this period of financial purgatory. For Isabella's lawyer, the goal is to move for a temporary support order, or an appellate bond that ensures the $4 million is protected and accruing interest while the clock ticks. Step by step, the appellate process is a grueling exercise in technicality. It begins with the designation of the record, where lawyers must decide every piece of evidence and every minute of testimony the higher court needs to see. Then comes the briefing phase. This is not a time for new evidence. The appellate court only looks for legal errors made by the trial judge. A lawyer in 2026 uses AI-assisted legal research tools to scan through tens of thousands of previous appellate rulings to find the exact precedent that supports their client's position. If Ethan's lawyer can find just one procedural error, perhaps the judge excluded a piece of evidence that should have been admitted, they can keep the case in limbo for years. While the appeal looms, the lawyer must also handle the Qualified Domestic Relations Order, or QDRO. This is one of the most technical and least understood aspects of the American divorce. You cannot simply tell a pension fund or a 401k provider to split an account because a divorce judge said so. Federal law under the Employee Retirement Income Security Act, or ERISA, requires a specific separate legal document that must be drafted by the lawyer, approved by the plan administrator, and signed by the judge. Historical trends show that thousands of people lose out on their retirement benefits every year because their lawyers failed to follow through on the QDRO process after the divorce was finalized. In 2026, the complexity has increased with the inclusion of digital native retirement accounts and decentralized pension protocols. The lawyer must ensure the wording is precise to the letter, or the plan administrator will reject the transfer, leading to months of additional litigation. Then there is the matter of contempt of court. Imagine if Ethan is not appealing, but he simply refuses to sign the deed to the vacation home or stops paying the court-ordered alimony. The divorce lawyer must then initiate an enforcement action, often called an order to show cause. This is a high-stakes proceeding where the lawyer asks the judge to find the non-compliant spouse in contempt. Step by step, the lawyer must prove that a clear order existed, that Ethan had the ability to comply, and that he willfully failed to do so. In 2026, this often involves presenting digital evidence of Ethan's spending. If Ethan claims he can't afford the alimony, but his lawyer finds social media data showing him on a luxury vacation in the Maldives, the court can order his immediate incarceration until he purges the contempt by making a payment. We must also look at the material change in circumstances. Support orders in the U.S. are rarely permanent in the literal sense. They are based on the financial reality at the time of the trial. But what happens 2 years later? Imagine if in 2028, Ethan's real estate business suffers a massive downturn due to a shift in the economy. His lawyer will file a motion for modification of support. This triggers a mini-trial where the lawyer must prove that the change in income is permanent, involuntary, and significant. Conversely, if Isabella's lawyer discovers that Ethan has secretly launched a new, highly profitable tech venture, they will file to increase the support. This creates a cycle of perpetual litigation that can last until the children reach the age of majority or the alimony term expires. Historical trends in the U.S. legal system show a shift toward using administrative enforcement for child support to alleviate the burden on the courts. Lawyers now work with state agencies that have the power to automatically garnish wages, intercept tax refunds, and even revoke driver's licenses or passports for non-payment. In 2026, these systems are integrated with real-time banking data. A divorce lawyer doesn't always have to go to court to find the money. They can trigger an administrative lien that freezes Ethan's bank account the moment a payment is missed. This technological integration has made the deadbeat strategy much harder to execute than it was in the 20th century. However, the most complex post-decree battle involves the relocation or move-away case. Imagine Isabella wants to move the children to a different state for a new career opportunity 3 years after the divorce. The original custody order is no longer functional. The lawyer must now engage in a high-stakes battle over the best interests of the child in a mobile society. They must analyze flight schedules, virtual visitation technology, and the comparative educational standards of the two locations. These cases are notoriously difficult for judges, and the lawyer's ability to present a workable, detailed parenting plan is often the deciding factor in whether the move is permitted. In 2026, we are also seeing the emergence of the digital legacy enforcement. Lawyers are now litigating over who has the right to manage a child's social media brand, or who gets the royalties from a family YouTube channel created during the marriage. These are assets that didn't exist when the current judges went to law school. The divorce lawyer has to be a pioneer, applying century-old property laws to digital assets that are generated in real time. If Ethan and Isabella's children have a significant following, the fight over the passwords and the revenue can be more intense than the fight over the house. As we look at this landscape of endless motions, appeals, and enforcement actions, it becomes clear that the divorce lawyer is not just a closer. They are a long-term strategist. They are building a legal fortress that must stand for decades. But as the legal profession moves further into the 21st century, A new force is beginning to reshape the very nature of these battles. We are standing on the brink of a revolution that might make the traditional courtroom obsolete. Next, we are diving into the rise of artificial intelligence and the virtual law firm, where we look at how algorithms are beginning to predict judicial rulings with terrifying accuracy, the emergence of the robot mediator, and how the next generation of divorce lawyers is using big data to settle cases before a human lawyer even picks up the phone. The transition from human-driven litigation to algorithmic resolution represents the most significant shift in the legal landscape since the introduction of no-fault laws. In the year 2026, the American divorce lawyer is no longer just a legal advocate. They are a high-level data manager operating within a virtual ecosystem. The traditional image of the mahogany-paneled office is being replaced by distributed legal networks where artificial intelligence handles the heavy lifting of discovery, valuation, and even the prediction of judicial behavior. This shift is not merely about convenience. It is about the weaponization of big data to create a version of legal practice that is faster, more invasive, and almost impossible to evade. Imagine a scenario in 2026 involving a character named Michael, a high-frequency trader, and his spouse Sarah, a digital marketing executive. In 1996, their lawyers would have spent months exchanging paper documents. In 2026, the discovery phase is initiated by a sentient discovery bot. This is a step-by-step automated sweep of the couple's entire digital existence. The bot doesn't just look for bank statements. It scrapes 10 years of social media interactions, analyzes the sentiment of every email sent between the parties, and cross-references GPS data from their vehicles with their reported business expenses. The result is a comprehensive dossier of veracity. If Michael claims he was at a business dinner in Chicago, but his wearable fitness tracker shows his heart rate spiked at a specific luxury resort in Cabo San Lucas, the AI flags the discrepancy instantly. This eliminates the he said, she said theater that has defined the profession for a century. Historical trends show that the cost of litigation was often driven by the human hours required to review evidence. In 2026, predictive analytics have turned that model upside down. Lawyers now use platforms that offer outcome modeling. These systems ingest millions of past cases, the specific rulings of the assigned judge, and the current market volatility of marital assets to generate a probability curve. When Michael's lawyer advises him on a settlement offer, they aren't relying on a gut feeling. They are looking at a dashboard that shows an 84% probability that a judge in this specific jurisdiction will award Sarah 42% of the high-frequency trading algorithm's future royalties. This data-driven approach forces settlements by making the risk of a trial mathematically clear. The rise of the robot mediator is perhaps the most controversial development in the 2026 legal market. Online dispute resolution, or ODR, has moved from small claims court into the complex world of family law. Imagine Michael and Sarah sitting in their respective homes, logged into a secure mediation portal. The mediator is an advanced language model trained in conflict resolution and state-specific statutes. Step by step, the algorithm identifies the zone of possible agreement. It analyzes the financial needs of both parties and the best interests of the children, then presents 3 optimized settlement scenarios. Because the AI is perceived as neutral and devoid of ego, historical trends in 2025 and 2026 suggest that parties are more likely to accept these algorithmic compromises than those proposed by a human lawyer, who might be perceived as having a financial interest in prolonging the conflict. The physical law firm is also undergoing a radical transformation. The 2026 divorce lawyer often operates in a virtual law office. This has led to the emergence of the unbundled legal service model. Instead of paying a massive retainer for full representation, clients like Sarah can purchase specific modules of legal help. She might pay for an AI-generated property division plan or a 3-hour strategy burst, with a human attorney to prep for a high-stakes video deposition. This democratization of legal services is a direct response to the historical trend of middle-class Americans being priced out of the traditional legal system. However, it creates a new divide: the algorithmically managed divorce for the middle class and the bespoke human-led war for the ultra-wealthy. Let's look at a case study of a smart contract settlement in 2026. In the past, if Michael failed to pay child support, Sarah would have to hire a lawyer to file a contempt motion. In 2026, their settlement is encoded into a self-executing smart contract linked to Michael's digital wallets and corporate payroll. The moment the calendar hits the first of the month, the funds are automatically transferred. If the payment fails, The contract triggers an immediate lien on Michael's non-custodial assets and notifies the credit bureaus. The lawyer's role has shifted from being an enforcer to being a coder of legal reality. They are drafting the logic that will govern these two people's lives for the next decade. However, this technological surge brings a new set of ethical challenges. In 2026, the American Bar Association is grappling with the problem of algorithmic bias. If an AI model is trained on historical data from an era where certain demographics were consistently disadvantaged in custody or support rulings, the AI may inadvertently bake those prejudices into its 2026 predictions. A sophisticated divorce lawyer now needs to know how to audit the algorithm. They must be able to argue that a settlement proposal is flawed because the underlying data set is skewed. This is the new frontier of advocacy, fighting not just the opposing party, but the machine that is trying to settle the case. The 2026 lawyer also uses biometric sentiment analysis during video depositions. As Michael testifies about his finances via a secure video link, the lawyer's software is analyzing his microexpressions, vocal pitch, and pupil dilation in real time. This provides the lawyer with a deception probability score. When Michael's voice wavers slightly while discussing an offshore account, the software highlights the moment, prompting the lawyer to dig deeper. This level of scrutiny was unimaginable in the 1920s, yet it has become a standard tactical requirement for an elite practitioner today. As we move deeper into this digital masterclass, we see that the profession has become a hybrid of high-tech surveillance and ancient psychological warfare. The divorce lawyer in 2026 is a data architect, a digital detective, and a behavioral economist all at once. They are navigating a world where privacy is a relic and data is the only currency that matters. But even with all this technology, the fundamental human element, the pain, the anger, and the desire for a new beginning, remains the core of the practice. The efficiency of the 2026 legal system is undeniable, but it leads to a haunting question. In a world where every asset is tracked, every emotion is analyzed, and every outcome is predicted, is there any room left for the human grace of a clean break? Or have we simply created a more efficient cage? The final chapter of this century-long evolution is not about the technology we use, but about the legacy we leave behind in the lives of the people who survive the process. We have seen the rise of the detective, the forensic accountant, the psychologist, and now the algorithm. But we are reaching the end of the road. One final evolution remains, the one that will define the next 100 years of the American family and the legal warriors who stand at its borders. Next, we are concluding this deep dive masterclass with the final verdict: the future of the American divorce, where we look at the emerging divorce as a subscription model, the potential for total legal automation, and the one thing an AI will never be able to replace in the courtroom: the power of a human story told by a lawyer who truly understands the weight of a life being torn apart. As we stand in the year 2026, the American divorce lawyer has completed a century-long metamorphosis from a shadow-dwelling investigator to a sophisticated architect of human transitions. While the automation of legal discovery and the rise of algorithmic mediation have stripped away the inefficiency of the past, they have simultaneously amplified the one thing that no machine can truly replicate: the high-stakes narrative. In a world where every bank transaction is tracked and every text message is archived, the role of the lawyer has moved into the realm of the storyteller. The battlefield of the next century is no longer just about who has more data, but about who can weave that data into a compelling argument for equity that resonates with the human experience. Imagine a scenario in late 2026 involving a couple named Marcus and Lily. They are part of the first generation to utilize what the industry is calling the subscription divorce model. For a decade, Marcus and Lily have paid a monthly fee to a legal tech platform that has maintained a living marital estate. This platform uses secure APIs to link every one of their financial accounts, property titles, and digital assets into a real-time ledger. Every time Marcus bought a fractional share of a commercial building or Lily invested in a new cryptocurrency venture, the platform automatically updated the marital balance sheet. In this 2026 reality, the traditional 6-month discovery phase, which historically cost American families billions in legal fees, is compressed into a single 30-second data export. The divorce lawyer's job in Marcus and Lily's case has shifted from being a treasure hunter to being a transition engineer. In this new model, the lawyer is hired not to find the money but to design the exit. Historical trends show that as the cost of information has dropped to near zero, the value of strategic advice has skyrocketed. Marcus's lawyer is no longer manually reviewing bank statements. Instead, he is using a neural negotiation engine to run 10,000 different simulations of the settlement. He is looking for the precise configuration of asset distribution that minimizes the long-term tax impact of the split, while providing the maximum liquid capital for Marcus's next business venture. This is the era of the bespoke outcome, where the potential outcomes are calculated with surgical precision before a single legal document is even filed. But the 2026 landscape has a hidden complexity that the early practitioners of the 1920s could never have imagined: the psychological toll of efficiency. When a marriage can be legally dissolved in 48 hours through a highly efficient app, the human heart often lags behind the legal reality. This has birthed the specialists known as the Collaborative Holistic Counsel. These lawyers in 2026 work in multidisciplinary teams that include behavioral economists and transitional psychologists. They realize that while the AI can divide the retirement account 50-50, it cannot address the emotional fallout of a 20-year partnership ending in a digital heartbeat. The modern lawyer must manage the grief-to-resolution pipeline, ensuring that the speed of the legal process doesn't cause a psychological collapse that leads to future litigation. We must also look at the rise of the private family sovereign. As public court systems in the U.S. became increasingly overwhelmed in the early 2020s, the wealthy began to retreat into private binding arbitration systems. By 2026, these private courts have their own set of rules and their own specialized elite of divorce lawyers. These lawyers operate in total secrecy, using non-disclosure agreements that are enforced with multi-million-dollar penalties. In this tier of practice, the lawyer is a ghost. They resolve disputes involving billion-dollar legacies and international dynasties, without a single word ever appearing in a public record. This historical trend is creating a two-tiered legal system: a highly automated, transparent public track for the general population and a dark, sophisticated private track for the global elite. Step by step, the final evolution of the divorce lawyer involves the management of the post-divorce digital legacy. In 2026, the marital estate includes things like the family's AI-trained personal assistants, the ownership of high-value social media handles, and the intellectual property rights to the couple's shared digital footprint. A lawyer today might spend weeks negotiating the custody of a family neural net, a personalized AI that has been trained on the couple's shared memories, recipes, and household preferences. Who gets the rights to the data that makes the house know how they like their coffee? This sounds like science fiction, but for the 2026 practitioner, it is a standard clause in a marital settlement agreement. The data suggests that the billable hour is finally facing its extinction. Clients in 2026 are demanding value-based pricing. A lawyer is no longer paid for how long they sit in a chair, but for the quality of the outcome they secure. This has forced law firms to become leaner and more tech-centric. The modern divorce firm looks more like a Silicon Valley startup than a traditional law office. They employ prompt engineers who specialize in extracting data from opposing AIs and narrative strategists who use psychological profiling to predict how a mediator will react to a specific set of facts. But even with all this technology, the 2026 courtroom, whether virtual or physical, still hinges on the power of the human narrative. When a judge is faced with a 50-50 split that is mathematically perfect but humanly devastating, the lawyer who can step away from the screen and tell the story of a parent's sacrifice or a spouse's hidden struggle is the one who wins. The last century has taught us that while the law provides the rules of the game, the human story provides the stakes. The elite lawyer of the future is a master of empathy in an age of algorithms. Case studies from this year show that the most successful potential outcomes occur when the legal team treats the divorce not as an ending, but as a corporate restructuring of the individual. They help the client rebrand, reinvest, and re-enter the world with a clean legal and digital slate. This is the true century of practice, the journey from the shame and secrecy of the 1920s to the transparent, high-speed, and data-driven liberation of 2026. We have moved from catching a spouse in a hotel room to auditing their soul through a digital ledger. The American divorce lawyer remains the most controversial, necessary, and resilient figure in the U.S. legal system. They are the ones who stand at the border of our most intimate failures and our most hopeful beginnings. As we close this masterclass, we realize that the next 100 years will be defined by the tension between the cold efficiency of the machine and the messy, unpredictable nature of the human heart. The tools will change, the speed will increase, and the data will become absolute, but the need for a human advocate to navigate the storm will never fade. The legal fortress has been built. The assets have been traced. The algorithms have run their simulations. But as we look toward the next horizon, a new question emerges. What happens to the concept of family when the law becomes so efficient that the consequences of leaving are no longer a deterrent. Next, we are exploring the birth of the post-marriage era, where we look at the rise of the co-parenting corporation and the secret legal structures that people are using to live together without ever being married in the eyes of the state, as we ask, is the divorce lawyer actually helping us break up, or are they teaching us how to never truly commit?